The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everyone. Welcome to the Appeals Court. I am Justice Rubin, and I am fortunate, and you are fortunate, because I'm joined by two excellent colleagues today, Justices Massing and D'Angelo. As is self-evident, as a result of some COVID illnesses, we are hearing argument by video conference today rather than in person in the courtroom. The rules for argument remain the same here as they are in the courtroom, which is to say 15 minutes per side and no rebuttal. A clock will appear in the panel where our seal is. It does not change color at a minute and a half as it would in the courtroom itself, but it'll be right. It's right obvious to you, and you'll see the time counting down. We are hearing one case this morning. It is number 22-173, Weeks versus Palmer Motorsports Park, LLC. And we will hear first from you, Attorney Curran.
Thank you, Your Honor. May it please the court, Dana Curran for Palmer Motorsports Park. The question in this case is whether the trial court properly found Palmer Motorsports in contempt of its January 14, 2020 judgment. A party who violates an order of a court may be found in contempt if the evidence establishes by clear and convincing evidence, A, the existence of a clear and unequivocal order, B, that the party in question knew of the order and its repercussions, and C, that the party intentionally disobeyed the order. It also must be possible to comply with the order. And in this case, we think it's problematic for a number of reasons. The January 2020 order required PMP to do three things. Within 45 days, PMP was required to undertake any noise mitigation. The order says, following which PMP was required to, I'm paraphrasing now, conduct noise studies on a high noise event and then provide the board with the actual noise readings from the study.
I'm sorry, something is going on with your microphone or something. It's getting blocked episodically. I mean, we haven't missed anything yet, but does that make sense?
I don't know what that is.
Seems okay now. Let's keep going, and we'll let you know if there's a problem.
I'll make sure nothing blocks where the microphone is, wherever that is. But in any event, one of the problems is that the order itself, I suggest, is ambiguous. The town takes the position that all three things had to be done within 45 days. That is the mitigation, the testing, and providing a report. The judge was a little bit vague on that. I think the judge sort of understood that it wasn't possible to do that all in 45 days. And my suggestion is that the only thing that had to be done in 45 days under this order was the mitigation, and that was done. Everything else is, it says, following which, the language.
Frank, can I ask you to address, I'm sorry, the attorney Heap raises this, and it's in Judge Vei's order on page 183 of the appendix, page 7 of his order, he lists the 5 issues for trial. And the second issue is if the answer to issue number 1 is yes, within 45 days from the entry of the judgment, PMP complied. So he imports the 45 days in that second issue for trial, and the plaintiffs say that your side never objected to that framing of the issues, and you sort of accepted that in the framing of the issues. Is that accurate, inaccurate? I'm
not sure if it was clear from that order whether the compliance was within 45, everything had to be complied with within 45 days. But I guess my answer to that is that it was not possible to comply within 45 days.
Well, before you get to that, I mean, did you accept that as the question for trial?
I'm not sure if we did. I think we framed it a different way. I think we framed it in terms of impossibility. But
and that was like a defense to why you didn't do it, as opposed to what the argument you made a minute ago about that the 45 days was not clear.
I don't think we understood that that meant 45 days for compliance with the testing requirements and submitting the raw data to the town.
So did you think there was no deadline for that? I'm trying to sort out what you.
I don't think we thought there was no deadline, but I think we thought at the earliest possible, probably at the earliest possible time. And here's the problem. The order entered on January 14, 2020. The park was closed at the time. It was not possible to do the sound measurements at that time.
Okay, can I stop you there?
Yes.
I assume you were not counsel at that time in the trial court, were you?
No, I was not.
Okay. How did the order issue? Was it issued in open court? Was it, were you served with it after motions were filed? How did your client become aware of the order in the first place?
It was a written order. The judgment entered. There was actually a written decision, and then there was a judgment, and it was this requirement was contained in both the order and the judgment.
And if I wanted to know what qualifies as a high noise event, where would I find that?
I'm not sure if I can tell you. I think it's I think there was testimony that it was a racing event.
Does it have to be a real race, or can you do a test of some kind?
I suppose you could get 40 race cars and have them race around the track. I don't know how you would do that.
Well, I don't know how you would do it either, but I don't run a race track. So
Right.
I don't really know how you get one race car, frankly, onto a race track.
I think the town was looking for, there were like 3 different kinds of events. There was like a club event, there was a race with 40 vehicles, and I think there was one other. So you had to pick one of those high noise events. I think the town was actually looking to have all 3 of them done at some point, but maybe after this order.
The problem that I'm having with impossibility here, and I understand your argument about the text and its clarity, and we'll have to look at that. But I'm not sure what it means to say the park was closed, so it was impossible. The park was closed, so you had no scheduled races, but that doesn't necessarily mean that doing a sound test is impossible. Maybe it's expensive. And I don't know at what point expensive becomes impossible. Do you have any thoughts on that?
Well, I mean, I don't think we understood that as requiring the testing, because I don't know how you test, how you run a race in January and February.
I don't know anything about that, but you didn't,
Right.
Not you, counsel didn't go back in and say, Your Honor, there's a mistake here. You've said it has to be within 45 days, but our race course isn't open. That would cost an enormous amount of money. Could you modify this? Because it seems to me that if you read this to require that the testing be done, and again, we'll have to parse this carefully, but if it requires the testing to be completed by February 28th, 2020, then you didn't do it. And the fact that you didn't have a race scheduled it doesn't seem to be dispositive of impossibility. Now you begin talking about COVID and laws shutting things down and restrictions. Yeah. I understand why that, but of course, February 28th is before COVID. So that's what and I understand this is not the way the judge did it. The judge sort of did this you know, it doesn't seem to me that this says anything about earliest practicable date if the microphones all work, or you know what I mean. It does. You know, like there's nothing in this order about that, and the judge sort of went down that avenue. And to me, it just seems to me the question is, what were you supposed to do by the date certain that was written there, and then was it impossible as of the date certain?
I think it was anticipated that there would be some racing starting in April, and of course, COVID shut that down. Now,
did you argue to the judge there was litigation that led to this order? Did you ever say to the judge prior to the order issuing? Because I also don't fully understand, can impossibility exist at the moment the order issues, or it has to be something unanticipated that comes up? You litigate it and the judge issues an order. Do you have no obligation to say to the judge, you've ordered us to do something, but it's metaphysically impossible to do it? You say do X, but the sun doesn't go high enough in the sky until, you know, April for us to do that at this latitude. You know, can you just rest on your rights? And then one day when someone says, hey, you're in contempt, can you go in and say, well, Your Honor, as I guess you should have known, the vernal equinox hadn't occurred yet. Do you see what I mean? It just seems very odd to me.
I do see what you mean, but I also suggest that, you know, we didn't understand that as saying the testing has to be done within 45 days, because you need to get a company to come in and do the testing and process the results and get you the raw data. And that's not going to happen right away.
Should the judge have known that? How would the judge know that? The judge is issuing an order and says, so 45 days, this has gone on long enough. Let's do the new test. I mean, do you have an obligation to say, Your Honor, I see that I've been ordered to do X, but you should know we don't have any race cars here. It's winter or whatever.
I don't know if the judge actually understood that as being within, everything's got to be completed within 45 days. Because when the judge went through his analysis, he then said, okay, well, there's supposed to be a race in April that was canceled. The track manager did go to the board in April and say, you know, we're not, our first high noise event is not going to be till this summer, till at least June.
And then there's a different judge entered the order than had heard the contempt, right?
I think it was the
same judge.
It was the same judge, Judge Vay.
Okay.
Counsel, can I try to it's sort of a mix of both justices' questions. So there was no objection made about the order being put in place and putting it in a 45-day limit, because you say you didn't really understand that there was a 45-day limit. Is that accurate?
I think that's accurate.
Okay. After the 45-day elapsed or sometime thereafter, did you ever seek clarification or reconsideration or modification of the order in any way?
Not of the order.
Okay.
What I suggest is that there was an effort to comply, and if I can give you a timeline, the first race was supposed to be in April, the first high noise event. That didn't happen. The first one that actually took place was in July. We commissioned a sound study. There were 4 locations, and 2 of the 4 failed. So there was another one on August 8th. That took place. There was a sound study done there that, you know, all 4 sensors worked. And one of the readings was high because some of the few days before the race, some of the sound baffles had blown down in a windstorm. The judge did not seem to give that a lot of significance. He's essentially said they're substantially in compliance with the noise, and you know, mitigation has been done. But then he said, well, on September 4th, you got a report and you didn't send that over.
But isn't it your position that there is no clear command here?
Right.
So you don't care. Once it's not 45 days, you can't be held in contempt of this order under your position. It doesn't tell you exactly what you're supposed to do or when, how hard you have to try, when you've done your best efforts, what to do before the report arrives, after the report arrives. What if the microphones break? I mean, your position is there's no clear command here. You could do nothing, presumably, and not be held in contempt. I'm not saying that's wrong, because contempt requires a clear command. And if we read it your way, following implementation of such measures, that doesn't tell us anything. That could be the year 2025, right? That would be following.
I mean, that's part of for purposes of contempt. There are other things going on. There's other litigation going on, but for purposes of contempt, there's no clear command. But, when you look back at the timeline, the judge seemed to focus on the fact that we got a report on September 4th and didn't send it until September 23rd.
Yeah, but that's look, if you don't have to do anything by any given date, then the judge can say that all day long. You were dilatory, but it's not contempt.
Right. But here's the next point. The unobjected to, unchallenged, undisputed evidence from the track manager was he got the actual raw data on September 23rd and he mailed it out that day. Yes, it was the day after they had filed contempt, but it was the earliest possible day that he could comply with the order, and he did that. So
but you don't say he had to act by the earliest possible day, right? Because there's no clear command that says earliest possible day.
I'm saying if he had to act by the earliest possible date,
he did.
But why couldn't your client have asked these people, look, as soon as you get the noise readings, send us the noise readings. That's all we're supposed to do is give the court the noise readings. Just give us the noise readings.
He did on September 23rd. He did.
They didn't exist before then?
What he had before was a report. They want the data so their engineers can do their own analysis. And it's the day he got it, he sent it out. No dispute about that.
Your time has expired, but I'm going to ask you another question.
Sure.
Maybe my colleagues do the same if they want to. Subparagraph D of the order, no later than 45 days from the entry of judgment 2. And then there is a subparagraph A and a subparagraph B. Is it not a rule of grammar that 45 days necessarily applies to subparagraph B, even though it's written in a funny, out of order, inartful way, that it is in fact clear that no later than 45 days you have to do A and B?
If you didn't have that first phrase, following PMP's implementation of such measures, if you didn't have that, I'd agree with you.
Well, but you could have written this more artfully, and it would have said, do within 45 days, you must complete all these tasks. Therefore, for purposes of your planning, you should be sure to implement the mitigation measures far enough in advance of that deadline that you can complete the providing the planning board the noise readings, because it all has to be done by 45 days. If it had been written that way, it would be more artful, but is it any different given that following, whatever the phrase is, following implementation is in subparagraph B, not outside of it?
I think it modifies the 45 days. I don't think they're necessarily both consistent, and that makes the order somewhat unclear and equivocal.
All right, I've taken too much of your time. Does someone else have a question, or we no further questions? All right, thank you very much. Interesting argument. We will hear now from Attorney Heap.
May it please the court, my name is Christopher Heap, and I represent plaintiff appellee Bonita J. Weeks in her capacity as building inspector and zoning enforcement officer for the town of Palmer. Now, this case has been going on for some time now. The underlying case was originally filed by my client in August of 2017. And in that complaint, Inspector Weeks sought zoning enforcement against Palmer Motorsports Racetrack for a violation of a condition contained in its 2007 special permit. That special permit condition required PMP to provide the town with actual noise readings from the track once it opened, and just for context there was about a 10-year gap between the issuance of the permit and actual construction and opening of the track. So the condition required PMP to provide actual noise readings once they opened to demonstrate that it was operating within the noise limits contained in modeling that was done prior to issuance of that permit. The underlying land court case was tried before Judge Vey of the land court in March 2018, and judgment entered, as we've discussed, in January 14th, 2020.
But can I ask a quick question about that? So
Yep.
here, there's a 2-year gap almost between the hearing and the issuance of the judgment.
There was a roughly 2-year gap, Your Honor, between the conclusion of the trial and the issuance of the judgment.
Because the judge writes, I don't know, this may have happened by then. This may have happened already, right? They might already have the mitigation for all I know.
So I was trial counsel for the plaintiff appellee back in 2018. And in the gap between the trial date and the issuance of the judgment, there was some question of sort of what to do about violation. So the Judge Vey effectively found a violation of the special permit on the spot at the conclusion of the trial, but then was left with the question of what to do next in terms of mitigation. So in the gap between the conclusion of the trial in 2018 and issuance of the judgment, there was some additional sound studying done by experts out at the track, which ultimately resulted in I believe some briefing prior to issuance of the judgment in late 2019 as to what relief the town was looking for.
Counsel, at the contempt, it was your burden to prove basically the elements of contempt. Would you
Yes.
agree with that?
Absolutely.
So tell me how you proved that in this case, the party knew that he had to comply within 45 days. What evidence did you put forward for that?
Largely the judgment itself, Your Honor. I've argued in my brief, and I was prepared to argue this afternoon, that the judgment is not in any way ambiguous with respect to the timing. The judgment, I believe, clearly states that, the judgment paragraph D of the judgment requires two things effectively of PMP. One, that it implement mitigation sufficient to bring itself into compliance with the applicable noise standard. And two, that it provide actual noise readings from the track capable of being reviewed by our peer review and sound engineer.
But if there's no racing going on, as your opposing counsel says, how are they supposed to submit those sound records, I guess?
I guess my first response would be that the judgment itself is open-ended in the sense that Judge Vey did not specifically tell PMP how it was going to demonstrate compliance. It simply said that it had to implement mitigation measures at the track to bring itself into compliance. And then
I guess that's sort of my question is, how can that be a clear, unequivocal order? The way I read the order, they could have put out one race car and brought it around the racetrack and said, here's the sound for that. Here's the records for that. And we've done it within 45 days. I don't think you'd be arguing, okay, they complied with the order, good enough. But if you go by the letter of the order like you want to do, that would comply with it, right?
No, Your Honor, that would not have demonstrated one car out on the track in February of 2020 would not have demonstrated compliance with the permit condition. Because the underlying modeling, and this gets a little bit into the weeds of the 5-year-old case, the underlying modeling predicted the noise that would result at the track if there were 3 categories of racing underway. One was 40 cars on the track, one was 24 cars on the track, and one was, I'm forgetting the third. But in order to the 40 cars on the track is the sort of upper theoretical limit of what this track, what noise this track could ever produce. So in order to demonstrate compliance with the condition, I believe PMP would have had to show noise readings of, if not 40 cars on the track, something approximating that amount. Now, what that would have, if it was fewer than 40 cars out on the track, they could have absolutely provided readings. Well, they could have provided readings of fewer than 40 cars on the track, provided their expert said, we believe that what we're showing you is sufficient to demonstrate compliance with the permit condition, at which point we would have had our peer review sound engineer review what they said and offer an opinion as to whether or not that it happened or not. If they said it did and we said it didn't, we would have been back in front of Judge Vey, arguing as to whether they had done enough under the judgment to demonstrate compliance with the condition.
So let me go back to a question that Justice Rubin asked. Does that mean impossibility? Is it sort of legal impossibility, or is it impossibility under the circumstances of the timing of this? Because in order to comply, as you just, and I think you did a great job explaining it, PMP would have had to have, I guess, paid drivers to bring their cars there in the middle of January, at least 40 of them, race around the track so they could have come up with these sound readings, but there would have been no race scheduled. Is that a legal impossibility, or just it really would have cost a lot of money, but that's PMP's problem?
That's not a legal impossibility. That's I've been working with and opposite the track for years now, and they have scheduled racing events all spring, summer, and fall. But I don't know that there's anything that I'm aware of, nothing that would have prevented them from enlisting 30 to 40 drivers to come out on a Wednesday afternoon to drive around the track.
So the only impossibility would have been if there was a blizzard and they couldn't drive around the track. That would have been an impossibility.
Correct.
Okay.
And there's nothing in the record that demonstrates why it's impossible, merely assertions that nothing was scheduled. Am I reading the record correctly?
I believe that's correct. I'm not aware of anything.
So your view is that they were in contempt on March 1, 2020.
Yes. And then I think I would say, and then dug themselves into a deeper hole for every day and week that passed.
But that's it's not quite window dressing, right? That's I don't know what those are optics that help you get a judgment, but they're not. It's not. I mean, if they were in contempt on March 1, then they were in contempt on March 1.
Can I ask about window dressing? Could you respond to Attorney Curran's argument that they got you the readings as soon as they could, which was September 23rd? That was the earliest possible date they could have gotten you the readings.
Respectfully, I think that's factually incorrect, and then Judge Vey, I think, found to that effect in his decision. The first testing that was done of a quote unquote high sound event at the track in the summer of 2020 occurred on July 16th, 2020. I believe their sound engineer was monitoring 4 locations and encountered difficulties at 2 out of the 4. Nonetheless, no information was provided from those July 16th noise measurements at the track to the town until after Inspector Weeks filed her complaint for contempt with the land court. In addition, the next monitoring that occurred after July 16th, 2020 was PMP arranged for sound monitoring to occur on August 8th, 2020. But again, in the immediate wake of that monitoring, the town was provided with no information whatsoever from PMP, and again, was not provided with any information until after Inspector Weeks filed her complaint for contempt. Finally, PMP, the record does reflect that PMP was in receipt of a sound report from its engineer as of September 4th, 2020, and PMP did not share that report with the town until.
Can I ask you a question? I think it's about the law. I think. It seems eminently reasonable to me that for purposes of a contempt citation, a court should be able to look at things like earliest practicable date. That should be relevant to the calculus. It is in so many other places. The party knows it's supposed to do this thing. Maybe it even knows it's supposed to do it by February 28th, but it's utterly burdensome, and so they don't. But if they then don't do it by the earliest practicable date, the judge will hold them in contempt. Maybe even wait till it is irrefutable that they could have acted sooner. But does that map onto our law about unequivocal commands and clear violations? Once we begin making it muddier, can we have a contempt? Do you have an answer to that question of how? Because that's how the judge looked at it, and there's something very reasonable about how the judge looked at it. But to me, as I said to your brother, if they didn't have to do it by February 28th, I don't know what day they had to do it by. And now we're going to ask what's practicable and not, when the order doesn't mention practicability.
I'm more than happy to work with a bright line of 45 days after the judgment. I think that's definitely the easier way to go. I
But
think
are there cases where, I mean, even with impossibility, okay, so the impossibility ends, right? There's a blizzard or whatever, a true impossibility, and then it ends.
Mhm.
Okay, but the order doesn't say, or if it's impossible, do it as soon as you can. Once it's impossible and you couldn't meet the deadline, when do they have to act, or they can never be in contempt again? It seems like a metaphysical problem or something.
I think I guess I'd fall back to the rule of law, Your Honor, that in order to invoke the defense of impossibility, the alleged contemnor must exercise diligence and be energetic in their attempts to comply with the order. And I would say here that PMP did not satisfy either of those two requirements in the defense of
Do you have
impossibility.
a case where a failure of diligence and energy was the basis for a contempt order?
I guess the Commonwealth versus 1987 Ford Econoline van example of where a party alleging the defense of impossibility was found by the court to really have sat on its hands and not done anything in an attempt to comply, and therefore the contempt was stood at the appeals court level. That's 413 Mass 407. Again, Commonwealth versus 1987 Ford Econoline van.
Counsel, there was nothing in the record, and I'm not necessarily saying there was an obligation, but there was nothing in the record submitted as evidence that anyone from your side contacted PMP and said, hey, when are you going to do these sound testing? When are you going to get the cars out there? There was nothing like that put into evidence, correct?
I don't believe so, Your Honor.
Is there any obligation on the part of somebody who's subject to an equivocal order to try and get it clearer?
I would say yes, Your Honor. I guess I wouldn't concede that this order is equivocal, but assuming it were, I mean, what we have here is PMP being issued a judgment from the Lane Court on January 14th, 2020.
Yeah, actually, I'm just cutting you off because your time short. The question is there a case that says if you're not sure about what the contempt order means, you better ask first. You better ask about it. It's your burden is on you to clarify.
There was Bear with me 1 second, Your Honor. I believe there is a case cited in sorry, I had it. New England Overall Co. versus Woltman, which is 343 Mass 659, which is actually a case cited in Judge Vay's decision itself, which has a court's order must be followed unless and until the decree is vacated in the trial court or is reversed in appellate proceedings. So I guess what I would take that to mean is that yes, if PMP thought this order was ambiguous, it didn't have the right to sit around and do nothing for 6 to 8 months. It really ought to, being responsible, it ought to have raised it with Judge Vay, either in the form of a motion to amend or request for clarification. It did not do that. It sat around and did, to the courts, from the court's perspective and certainly from the town's perspective, did nothing until after September 20th, when the complaint was for contempt was filed.
Oh, do you have further questions, Judge?
Yeah, please. So as I understand it, right, at this point, the order has been complied with, and we're talking of the contempt judgment. It was relevant as attorney's fees, right?
So the attorney's fees and ongoing serial monitoring on a I think ongoing basis until such time as PMP has demonstrated fully compliant.
Okay. And could a judge like not find the party in contempt but still order fees?
I don't know the answer to that question, Your Honor. I believe victory on the finding of contempt was likely a necessary component of our award of attorney's fees.
Thank you.
All right. Your time has expired, although if there are further questions, I'm happy to entertain them. No. Thank you very much both for excellent arguments. It's a surprisingly interesting case. That's a kind of law school hypothetical quality to it. So thank you both for your assistance today. That is the last case we are hearing today, and consequently, the case is submitted.